It's major gaffes that administrators and executors make in probate. And probate, mistakes abound sometimes. So there's some things that administrators and executors really have to watch out for. And we'll talk about those and maybe how to prevent them or avoid them. Welcome back to the channel. I'm Brendan Mohr, California Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional California fiduciary. I'm also a licensed California real estate broker, a licensed Nevada realtor, and I'm a bonded and registered legal document assistant in both California and Nevada.
Now, please like our video right now, subscribe to our channel. Want your probate done for little to no cost? Well, every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo. So please reach out to us about that, or reach out to us with any questions about probate real estate. Comment on this video. Our contact information is below, so please email, text us, call us, because we can help you. So Bill, there's some major gaffes that administrators or executors can make in probate, and there's a whole lot of them, and you've seen a lot of them. But what's one that really sticks out to you first and foremost?
I would have to say that one of the biggest gaffes or mistakes that I've seen is when administrators or executors distribute monies, funds out of the estate to the heirs without a court order. Oh my gosh, that's just a huge mistake that some of them make. Some of them think that, you know, you sell the probate home and the money comes into the estate account. Okay, now I can just send out the money to all the heirs. And no, you can't do that. You have to have an order from the court. And if you don't have an order from the court, you could be setting yourself up to get into some big trouble with the court. So yeah, that's a biggie. That's a biggie.
Yeah, I mean, I've had people think that once the house sells, they automatically get all the money, and maybe even plan their life around it. Sometimes we have people living in the house and thinking that once the house sells, then they can go buy a house or rent a house at that point. There's certain things that sometimes can be helped with helping them find a new place and rent, but yeah, those funds are tied up until the probate closes in most cases.
Yeah, and there's good reason for that, because part of probate is to protect the interest of the creditors. You know, there might be creditors out there that the person who passed away owed money to. And if you distribute the money without a court order and the creditors haven't been given their proper notice and time, that's a huge problem. I mean, you can get into big trouble.
And I know of situations where heirs have reached out to you when you're probating the estate as the administrator, or just the one probating the estate reaching out to you and demanding funds, like saying, hey, can you get me funds?
Yeah, well, I have to tell them, no, I can't do, I have to have a court order to do that. There is a way you can petition the court for a preliminary distribution, but again, you have to have a court order to do that. You can't just on a whim distribute funds. It's a big no-no.
And sometimes it's someone who's pro per, or they are the court-appointed administrator or executor. They have access to those funds. They can get in a lot of trouble.
Oh, sure, yeah. I mean, as a professional fiduciary, I mean, that's my job when I'm the administrator of a estate, is to make sure that everything's done by the book and proper records and nothing's distributed unless the court orders it. So yeah, you have to you can't just throw estate money around like that. You can't do that.
Now this next one, it's not so much real estate related, but I've heard you talk about it before. Not liquidating stocks or mutual funds and stuff like that.
Yeah, that's kind of a tricky one because, and again, I know we've said this before, but I'm not giving legal advice. I'm just giving advice from experience. But in general, the court wants whoever's in charge of the estate, administrator, executor, to preserve the estate assets for the heirs. So when someone passes away, if they've got a lot of stocks and bonds in their estate, well, obviously those are going to fluctuate up and down with the market. And probate on average takes a year, sometimes longer. And what you don't want to do is you don't want to be caught in a position where you started the probate, you had all these stocks and bonds in the estate, you got your appointment, you kept them in the stocks and bonds, you didn't cash them in and put them in the estate account. And let's say 6 months later, the stocks take a huge drop and there's, maybe a $50,000, $100,000 loss to the estate, which you could have eliminated by simply cashing out those securities, equities, when you got your appointment, and put all those funds into an FDIC insured estate bank account. That's what you should do. I've seen that happen. In fact, I had a probate recently where the woman who was in charge of the estate, she didn't cash them out until the end of probate, and she lost about $40,000 to the estate. Now, some people will say, hey, but the stocks could go up. Yeah, sure, they could go up, but nobody can predict the movement of the market. So, you're far better off to cash them out when you get your appointment, set them into the estate account so that they're there. Nothing's going to happen to them until the end of probate. You make the distribution.
Yeah, that's really important in protecting the assets of the estate.
Yeah, you have to. That's a big part of your job as the administrator of the estate, is to protect the assets for the heirs. Very important. Now, Brendan, how about I'm gonna throw one back to you, and you've seen this before. What do you think about the administrator taking money out of the estate account and using it for personal reasons?
Oh my gosh, you can't do that. That again, just what you were talking about right there. When it comes to protecting the assets of the estate, one, if there's other heirs involved, of course, they're not going to like that. Mm-hmm. You're out there using those funds. But even if you're the only heir of the estate, there are creditors. Or there could be creditors. Sure. Creditor claims that you don't even know about. You may be really confident there's no creditors out there, but there might be somebody.
Yeah.
And I know that you've had it in the past where heirs have reached out to you about wanting money, and maybe there's certain times that can happen, but there's a lot of reasons why.
Yeah. In general, you can't. Yeah, you shouldn't be doing that. No, it happens. But and there's another one that major gaffe that I just kind of want to bring up, that it's, and we talk about this particular document in other videos, but the notice of proposed action. This is something that a lot of administrators and executors don't always do, especially when they're probating the case on their own. We both know that when you're selling a probate home, real estate, that it's critical that the notice of proposed action forms get done up properly, they get sent out properly, notice is given to all the interested parties about the sale. But there's also other times too when a notice of proposed action you want to use it. For example, if you're going to sell a vehicle, although you don't necessarily have to do a notice of proposed action, you should do one. Anytime there's something coming up that could involve property of the estate, not necessarily the house, could be a vehicle, could be a valuable coin collection, even the stocks and bonds. It's okay, and it's actually extra protection to go ahead and do a notice of proposed action for that particular event as well. And sometimes what happens is administrators, executors, they don't do a notice of proposed action to sell Uncle Joe, who passed away, his valuable 1954 Oldsmobile. And you go ahead and sell it without doing an NOP. And even though it's technically okay to do that, one of the heirs says, hey, I don't like that. And, they can start causing problems for you. So you want to use that NOP form pretty much all the time. Yeah.
It's a very important form when it comes to the sale of real estate.
Yep.
And it's always one of those things I'm asking you about. And sometimes I'm asking if there's an attorney involved. I'm asking the attorney, like, hey, we got to get that out, right? Get that out quickly.
Yes.
It's very, very
Absolutely.
important form.
Yeah. Now, one major gaffe I'll throw your way is, what about signing a listing agreement before you get your appointment?
Oh, before you get the appointment. Okay, so yeah, that I've heard of that happening, and I've had clients where they had entered into a listing agreement with a different agent at some point who maybe didn't really understand the process, and a lot of realtors really have not ever been involved in a probate sale and come to me a lot, and we get a lot of realtors watching our channel, and we appreciate that. We always appreciate their questions. Yeah, when it comes to the listing agreement, you cannot ratify a listing agreement until the letters have been issued granting an administrator or executor and whatever authority they have, full or limited authority. That is the document that allows that individual or multiple people to have that authority to enter into that agreement.
Yeah, I just as a side note to what you're saying, I've spoken with and seen a lot of people who are named as the executor in the will, and they're going to act as the executor. But I've seen people who they're the executor of the will, no probate has been filed, and they don't necessarily think they have to file probate, but because they're named executor in the will, they go ahead and think they can sign a listing agreement and sell the house. And no, you can't. Just because you're named executor, you still got to get that appointment. You still got to get those letters from the court in order to do that.
I can only imagine being the realtor on that side of things if I did not know that, that you could put this into contract and get all the way till, well, an accepted offer. And most likely at that point, the title company's gonna say, "Hey, so where are the letters at?" They're gonna, but some title companies, some title or escrow officers haven't really done a whole lot of probate either. No. They might not ask for the letters until close to closing.
Yep.
So, oh my gosh, you really have to know that process there. Plus, when it comes to a listing agreement, and we talk about it in some other videos, so please watch our video regarding listing agreements. They're only actually valid in probate for a certain amount of time. It's actually controlled by or regulated by statute. They can't just be an unlimited amount of time or for a year or anything like that. There's a limited amount of time that a valid listing agreement in probate can
right,
be for.
Exactly. And just to kind of tail on to what we just talked about, another big gaffe, which I know you're aware of and know about, but what about signing an actual purchase agreement before you have your appointment?
Oh my gosh! I mean that's I guess what I was alluding to there.
Yeah.
You're going to accept a purchase agreement, and when a realtor accepts gets a purchase agreement signed by a buyer sends in an offer, and the seller, in this case, whoever thinks they have the authority, signs it. A realtor sends that over to their escrow officer. Now, the escrow officer may or may not have asked for certain things at that point, like the letters. Now, if they're experienced in it, maybe they have asked for certain questions, but you could get all the way to the end of the escrow period and find that nobody has the authority. Okay, so now you just cause someone a buyer to probably pay for all their inspection fees, maybe an appraisal fee. That could be $1,500 total, as well as all of their time. They thought they're going to move into a house. Maybe they were even had other loan costs that they've already paid for, and all the way to the end there, and now it can't close. And just to get the court-appointed administrator or executor at that point, it could be months.
Yeah, and in addition to that, if an administrator and executor, I would think, signs a purchase agreement without having the authority really to do it, maybe you're setting yourself up for a lawsuit coming from those buyers who you gave them the impression that you had the authority to sign and sell a listing agreement, sign the purchase agreement, and sell the house, and you didn't. I don't know. I wouldn't want to be an administrator and executor in that position. I just wouldn't.
Yeah. Now, there's one that I've thought of, but we're going to talk a little bit more about this in an upcoming video where we talk about what an administrator or executor should not do when listing a probate sale. But I'll touch on it just a little bit, and it has to do with, you talked a lot about the financial part of it, that an administrator or executor needs to really protect the estate or look out for the estate's finances and do everything they can to do that. But something that I have seen is an executor or administrator waiting far too long to get the home on the market and the home falling into disrepair, needing tens of thousands of dollars in improvements, having to pay for the property taxes, utility bills, and other things, liens that were attached to the home, just continuing to collect interest, to where I've seen a case where if I had estimated that particular case, it may have cost $100,000 in overall costs for that particular estate.
Yeah, and like I've said, and you were just making reference to, an administrator executor who doesn't think about that is not really protecting the estate assets, because they just continue to lose money by postponing going on the market to get that home sold.
Time in most cases are not on your side in this, so that's why when one of the biggest gaffes maybe administrators or executors make is not hiring you to do their service for you, because you get it done fast. You have all the reason in the world to get it done very quickly, and getting probate done from start to finish is very, very important. And you can probably find the best service for that by talking to a realtor who has done probate many, many times. So maybe one of the first things you should do if there is probate involved is actually talk with a realtor who has known the probate process really well. So
has experience.
Yeah, so I think maybe a great video for you to watch is linked next. It's called How to Hire a Probate Realtor. It's 10 interview questions for hiring a probate realtor with a downloadable list with an additional 5 questions, so 15 questions. And if you're talking with a probate realtor who has done it many times, they have a suggestion on who to work with. That video is here right above Bill's head.